providing for the procedure of removal of a county governor or ON of the grounds mentioned in Clause 1. Now, Section 33 of the County Governments Act, Standing Order 8 of the Senate, and Part 1, and the third schedule to the Senate Standing Orders, provide for the procedure to be followed in hearing and determination on the proposed removal from office by impeachment of a county governor. Specifically, Section 33(3) and Standing Order 81B of the Senate provide that the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter or investigate the matter in plenary. Honorable Senators will recall that at a sitting of the Senate held on Tuesday, the 8th of October 2024, the motion for the establishment of a special committee was defeated. This therefore paved the way for the investigation on the proposed removal from office by impeachment of Honorable Dr. Erick Kipkoech Mutai, the Governor of Kericho County, to be held in plenary. Now, Honorable Senators, ladies and gentlemen, by way of status update, pursuant to Rule 4A and 6 of the Rules of Procedure when considering the proposed removal of a governor in plenary, the Senate invited the governor to appear and be represented before the Senate during this investigation. The Senate further invited the governor, if he so chooses to appear before the Senate, to file an answer to the charges with the office of the Clerk of the Senate by 5 p.m. on Saturday, the 12th of October 2024, setting out the following: the governor's response to the particulars of allegations, be the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3, the names and addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. And 4, any other evidence to be relied on. Pursuant to Rule 4B and 7 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, the Senate notified the County Assembly of the date for the commencement of the investigation and invited the County Assembly to designate members of the County Assembly who shall appear and be represented before the Senate during the investigation. The County Assembly was further invited, if he so chooses, to appear before the Senate, to file with the office of the Clerk of the Senate by 5 p.m. on Saturday, the 12th of October 2024, setting out the following documentation: designating the members of the County Assembly, if any, who shall attend and represent the Assembly in the proceedings before the Senate. 2, indicating the mode of appearance before the Senate, whether in person, by advocate, or in person and by advocate. 3, indicating the names and the addresses of the persons to be called as witnesses, if any, and witness statements containing a summary of the evidence to be presented by such witnesses before the Senate. 4, specifying any other evidence to be relied on. Honorable Senators, ladies and gentlemen, on Saturday, the 12th of October 2024, the Office of the Clerk of the Senate received a response reference number 1/816/24/1 and dated the 9th of October 2024 to the invitation to appear issued to the Governor of Kericho County from Messrs. Katwa and Kemboi, who indicated that the Governor had appointed the firm to represent him in the proceedings before the Senate, and that the Governor would also appear in person and by advocates. The letter also indicated the list of counsel representing the Governor and the list of witnesses to the Governor. Similarly, on Saturday, the 12th of October 2024, the Office of the Clerk of the Senate received a response reference number HNK/009/007/2024, dated the 12th of October 2024, to the invitation to appear issued to the County Assembly of Kericho from Messrs. H&K Law Advocates, indicating that the firm had been appointed to represent the County Assembly. The letter also indicated the advocates represented the County Assembly and the witnesses for the County Assembly. Pursuant to Rule 8 of the Rules of Procedure, when considering the proposed removal of a governor in plenary, on Saturday, the 12th of October 2024, the Clerk of the Senate furnished each party with a documentation filed by the other party in accordance with Rule 6 and 7 of the Rules of Procedure. Honorable Senators, ladies and gentlemen, the hearing program, which has been appended in today's order paper, details the various activities in the hearing and determination of the matter and the time allocated to each activity. It will be crucial that all parties comply with the time allocated.
The parties will be notified of the balance of time on each activity through the clerk at the table. In summary, the program states that today, Monday, the 14th of October 2024, after we have dispensed with the preliminary matters, the charges against the governor as submitted by the County Assembly shall be read. The governor will be given an opportunity to take a plea on the charges. This will be followed by an opening statement by the County Assembly and thereafter by the governor. After the conclusion of the opening statements, the presentation of the case of the County Assembly shall commence. The County Assembly will have a maximum of 3 hours for presentation of the case and re-examination, while the governor will be allowed 2 hours for cross-examination of the witnesses presented by the County Assembly. After presentation of the case by the County Assembly, the cross-examination by the governor and re-examination by the County Assembly, honorable senators will be given an opportunity to ask questions or seek clarification from the County Assembly. These activities will proceed until the conclusion of today's sitting. At the sitting scheduled for tomorrow, that is Tuesday, the 15th of October 2024, the governor will have an opportunity to present his case before the Senate. Similarly, the time allocation will be 3 hours for the governor's case, including re-examination, and 2 hours for the County Assembly for cross-examination. Honorable senators will also be given an opportunity to ask questions or seek clarification from the governor, following which closing statements by the parties will be made for a period not exceeding 1 hour each. The Senate shall thereafter proceed to a debate on a special motion prior to voting on each of the charges. At this stage, a supplementary order paper will be issued to facilitate this debate. The Senate shall thereafter proceed in accordance with Section 33(7) of the County Governments Act and Standing Order 86 of the Senate Standing Orders. The voting shall be by county delegations. The governor shall cease to hold office if a majority of all county delegations vote to uphold any impeachment charge. However, if the vote in the Senate fails to result in the removal of the governor, pursuant to Standing Order 87 of the Senate, the Speaker of the Senate shall notify the Speaker of the County Assembly of Kericho accordingly. Now, honorable senators, ladies and gentlemen, I now invite counsel for the County Assembly of Kericho to introduce the legal team of the County Assembly and the members of the County Assembly of Kericho representing the County Assembly by stating the full name and designation of each person. Counsel for County Assembly, proceed. Before the council introduces his team, Senator Fatuma.
Mr. Speaker, on Wednesday, you gave a position that you are going to give a decision on Isiolo matter, which is now. So I'm kindly requesting, and I'm sure Isiolo people are also waiting for your decision on this matter. This is a very serious, weighty matter, Mr. Speaker, and it's good if the House gives direction, because as we are speaking, Mr. Speaker, Isiolo people are suffering. We are not getting service delivery at all. People who are in hospital, even those who are on oxygen, they are sent home. There is no service delivery at all. Mr. Speaker, kindly give us direction on this. I thank you.
Very well, Senator Dulo. I will give my communication in the course of the day. Proceed, counsel for the County Assembly.
Very good morning, Mr. Speaker, sir, honorable senators. For the Kericho County Assembly, the representation is as follows. Myself, Kimutai Bosek, Mr. Charles Njenga, advocate, Sharon Mibei, advocate, Elias Mutuma, advocate, Kiplangat Hillary, advocate, Winnie Bet, advocate, Langat Geoffrey, advocate, Kipkorir Elvis, advocate. Then we have also our legal assistant, Brian Lee Maingi, and Ian Kiplangat. We also have our technician, that is Mr. Kipkoech Jaffet. Mr. Speaker, sir, honorable senators, we have as our
witnesses for the Kericho County Assembly. Honorable Kiprotich Rogony, member for Sigawet Ward. Honorable Albert Kipkoech, member for Soliat Ward. We also have affidavit from Mr. Josiah Kogo, and we have an affidavit, and also we'll be asking or lining up Mr. Erick to testify before the Senate. And lastly, we have a lady whom we have given a pseudonym because of the sensitivity of the evidence she'll be adducing. And for now, we are calling her Kericho daughter. After introduction by our colleagues on the other side, Mr. Speaker, sir, Honorable Senator.
Just wanted to say also that we had sent a communication to your office that we propose to raise a preliminary objection. That's one. And
Counsel for Governor.
Yes.
At this juncture, you're just to introduce the legal team and take your seat, please.
Thank you, Mr. Speaker.
Thank you. Honorable Senators, ladies and gentlemen, on behalf of the Senate, I welcome the County Assembly team, the Governor's team, members of the public, and the media to the Senate and to these proceedings. As you're aware, Article 118 of the Constitution mandates Parliament to conduct its business in an open manner, and that its sittings and those of its committees shall be open to the public. The hearing of the proposed removal from office of the County Governor, pursuant to Section 33 of the County Governments Act and Standing Order 8 of the Senate, is a matter that generates immense public interest. The Senate, and in this particular hearing, has facilitated the members of public who are interested in these proceedings to access its galleries. However, I draw the attention of the members of public who are seated in the galleries to Rule 28 of the Speaker's rules, which states as follows in part: visitors in the galleries shall remain seated and shall not applaud, comment audibly, make signs, eat, sleep, read books, newspapers, or other matter except the order paper for the day, or create any disturbance. I request the members of public to observe the aforesaid rule. Any member of the public who contravenes the Speaker's rules
will be inviting stern action against them, which includes expulsion from the precincts of Parliament. The office of the Clerk of the Senate is directed to ensure compliance with the Speaker's rules. Honorable Senators, ladies and gentlemen, finally, I now invite the Clerk to read the charges against Honorable Dr. Erick Kipkoech Mutai, the Governor of Kericho County.
Proposed removal from office by impeachment of Honorable Dr. Erick Kipkoech Mutai, the Governor of Kericho County. Particulars of the allegations. The Honorable Dr. Erick Kipkoech Mutai, the Governor of Kericho County, please take the stand. The Honorable Dr. Erick Kipkoech Mutai, the Governor of Kericho County.
The grounds for your proposed removal from office by impeachment, as received by the Senate from the County Assembly of Kericho, are as follows. Ground 1, gross violation of the Constitution and other laws. Gross violation of the Constitution of the Republic of Kenya 2010, the County Governments Act 2012, the Public Procurement and Asset Disposals Act, the Public Finance Management Act 2012, and the Kericho County laws. The particulars of this ground are as follows. Allegation 1, misappropriation, misallocation, and illegal drawings of county revenue and county finances. On various occasions since his election as a governor and subsequent assumption of office, the governor has engaged in various acts of gross violations of Articles 10, 183, and 201 of the Constitution, Sections 102 and 109 of the Public Finance Management Act, Cap 412A, and the provisions of the Kericho County Rating Act, number 5 of 2019, as follows. A, presiding of an administration which has deliberately refused
failed, neglected, and omitted to automate revenue collection, thus opening up the county's own source revenue to pilferage, misappropriation, and theft. B, the county government advertised for the procurement of the Integrated County Revenue Management System via an advertisement dated 14th December 2023. Despite the tender being responsive and a compliant tenderer being proposed by the tendering committee for the award of the tender, there is evidence that the governor frustrated the award of the said tender. C, the absence of the automated payment system has adversely impacted on the revenue-raising ability of the county through deliberate undercharging of business permit fees and miscategorization of zones where businesses are actually situated. For instance, single business permits are issued to the business owners at zones B and C, which attract less charges when the actual business is situated as zone A to avoid payment of the actual charges. Similarly, properties situated in areas that attract higher rates are miscategorized, charged, and issued clearance certificates for areas that are zoned for lower rates, thus perpetuating revenue leaks. D, the governor presides over an administration that has totally disregarded the valuation roll prepared and passed by the County Assembly in 2019 pursuant to the Valuation and Rating Act, Cap 266. Thus, the county continues to collect property rates under the old valuation roll, occasioning the county substantial revenue losses. C, the revenue leaks and losses has seen the county miss revenue targets for 2 consecutive financial years, whereby the revenue collections fall short of the projected revenue by more than 50%. F, the governor has violated the provisions of Section 104 of the Public Finance Management Act 2012, whence through his acts of omission, commission, and inaction, he continues to preside over a broken public finance management system which has made the county treasury ineffective. G, there is a nexus between the disappearance and or loss of the county revenue and the governor's opulent lifestyle since he was elected. Indeed, within 2 years since his election, the governor's wealth has grown exponentially, so much so that he can now afford to contribute up to 1 million shillings in a single harambe. Indeed, in one church function, the governor was captured bragging that whereas he didn't have the resources when he first vied, and I quote, Ra ko mi tuguk, loosely translating to, this time I have enough resources. 2, on or about 31st of August 2023, the governor engaged in gross violation of Articles 10, 183, 201, 207, and 208 of the Constitution and Sections 102, 109, and 110 of the Public Finance Management Act 2012 by launching a program dubbed Equalizer Kazi Mtaani Initiative and drawing county funds towards the initiative without a legislation to anchor the initiative, public participation, prior approval of the County Assembly and the Controller of Budget, and prior approval of the Budget and Appropriation approval. 3, the present and former Chief Executive Committee members and chief officers have variously reported coercion by the governor to make financial allocations for the governor's own use from the funds allocated to their respective departments, and which funds they were required to remit through the governor's personal assistants. 4, violation of Articles 201A, D, and E of the Constitution of Kenya 2010 on principles of public finance management, and Article 226 as read with Article 227 of the Constitution by presiding over glaring irregularities evidenced by A, irregular award of contracts and evasion of accountability, B, willfully interfering in the procurement processes and the award of tenders, C, skewed tender awards to various contractors at inflated rates and in collusion with fraudulent contractors and suppliers, D, irregular implementation of various programs in the county, and E, intentionally and negligently presiding over massive theft of county public funds, as evidenced by the Auditor General's report for the financial year ended 30th June 2023, which raised
red flags over various projects. 5. On 15th August 2023,
the Governor compensated the victims of Londiani accident from the county emergency funds to cover up for the funds raised by the public and misappropriated by a committee he had formed to steer the funds drive, and without a cogent explanation of how the funds publicly raised for the misappropriation of publicly raised funds. That on various occasions, on various dates between 4th July 2023 and 9th July 2023, the Governor grossly violated the provisions of Articles 10, 73, and 75 of the Constitution and Sections 29 and 34 of the Leadership and Integrity Act 2012 by A. Overseeing misappropriation of the funds raised for the victims of the horrendous Londiani Junction accident tragedy, in which over Kenya shillings 9 million of publicly raised funds were lost. B. Reneging on his undertakings to implement the report of the County Assembly's ad hoc committee formed to probe the misappropriation of funds meant for the victims of the accident. There is evidence that the Governor filed a suit and or supported a suit by those implicated in the report of the County Assembly's ad hoc committee in Kericho ELRC petition number E006 of 2023, Dr. Wesley Bor and 5 others versus the Governor, Kericho County Government and others, and Kericho ELRC petition number E014 of 2023, Victor Tum and others versus the
Governor, Kericho County, and others. C. Being personally and directly complicit in the flawed award of direct tenders for service providers during the fundraiser and the requiem mass of the victims of the accident. D. The county governor has, in this regard, committed numerous and various acts in the course of his duties that are contrary to and in violation of the Constitution and the laws of Kenya. These include: 1. The authenticity of various payments made cannot be confirmed. The fact that the exact amount of money expended from the sum collected during the fundraiser points to impropriety and suggests a clear fraud on those whom the funds ought to have benefited. 2. A total of Kenya shillings 13,682,660 was collected at the fundraiser. A sum of Kenya shillings 423,000 was purportedly expended as pastor's facilitation, transport refund, fuel preparation, lunches and refreshments, printing, publishing and radio announcements. Other payments that were approved from the fund were: Kericho County Referral Hospital, Kenya shillings 2,037,524. Londiani Hospital, Kenya shillings 1,534,190. Supertix Limited, Kenya shillings 2,945,000. Supershine Limited, Kenya shillings 411,000. Raise Hospital, Kenya shillings 100,000. County Commissioner's Fuel, Kenya shillings 300,000, etc. 3. That when Kenyans from all walks of life voluntarily made contributions to aid the victims of the tragedy, it was never intended or anticipated that the funds would be misappropriated with the blessings of the governor, who had a higher calling to ensure the money is accounted for to the last coin and on whom the people bestowed their trust. 4. The governor has issued contradictory statements insofar as the use of the funds is concerned. The contradictory statements point to his being complicit in the matter. And 5. While the governor is on record indicating that the medical bills for all the victims would be waived and taken care of by the county government, it is not clear why money had to be paid out from the fund collected to various public hospitals against the express and unequivocal representations of the governor. E. By his acts of omission and commission, the governor has grossly violated the provisions of Article 75 of the Constitution, which demands that a state officer shall, whether in private or in public, behave in a manner that avoids conflict of interest between personal interests and public or official interests, or compromises public interest in favor of personal interests. F, by overseeing the misappropriation of the funds aimed at assisting the victims of the accident, the governor violated Article 73(2), which demands from him selfless service based solely on public interest, demonstrated by honesty in the execution of his duties, accountability to the public for decisions and actions, and discipline and commitment in service. G, by allowing himself to be a master of doublespeak in such a grave matter that shook the conscience of the nation, the governor violated Article 73, 1A, Roman 2 and 3 of the Constitution, which demand that he at all times demonstrates respect to the people and brings honor and dignity to the office he holds. H, by allowing himself and senior officials close to him to benefit from the funds, the governor violated Article 76, 2B of the Constitution, which prohibits a state officer from accepting a benefit in circumstances that compromise the integrity of the state officer. And I, by failing to ensure that decision-making in the executive office of the county governor are not influenced by corruption, nepotism, and other callous and improper motives, the governor has failed to exercise objectivity and impartiality, thus violating Article 73, 2B of the Constitution of Kenya 2010. The Honorable Dr. Erick Kipkoech Mutai, how do you plead to ground 1, guilty or not guilty?
Not guilty.
Ground 2, abuse of office. The particulars of this ground are as follows. Allegation 1, illegal appointments, unlawful dismissals and transfers, and usurpation of the constitutional and statutory functions of county public service. That the governor has variously engaged in 1, gross misconduct, and 2, gross violations of Articles 10, 73, 75, 232, 235, and 236 of the Constitution. 3, gross violation of Section 17 of the Public Officer Ethics Act, Sections 55, 59, 59A, 60, 62, 63, 64, and 65 of the County Governments Act, Section 4 of the Public Appointments County Assemblies Approval Act 2017, and variously abused his office by A, illegally appointing 1 Mrs. Alice Bett, now a judge of the High Court, as the county attorney when there was a substantive office holder, an act which the Employment and Labor Relations Court, the Honorable Lady Justice Wasilwa, affirmed was irregular, unprocedural, and unlawful in the case of Sang versus Governor Kericho County and 2 others, petition number E001 of 2023. In that case, the governor was found by the court to be in gross violation of Article 73 and 232 of the Constitution, his actions found to be illegal and unconstitutional, and ordered to pay Kenya shillings 2 million and costs personally. The governor has therefore been already adjudged to be in gross violation of the law, and all the Assembly and the Senate are called upon to do is to remove him by impeachment. B, causing the advertisement of the positions of doctors, nurses, early childhood education teachers, just to endear himself politically when he knew the county government did not have the capacity to hire. The applicants were subsequently not shortlisted, nor the alleged vacancies filled up. C, illegally deploying health staff via notice dated 22nd of July 2024 without any justification, authority, and involvement of the County Service Board, thus creating a crisis in the health sector. And D, illegally appointing Mr. George Kipngeno Kirer as the Chief Officer for Finance and forwarding his name to the County Assembly for vetting and approval when there was a substantive office holder in the name of Ms. Jacqueline C. Langat and the vacancy had not arisen. Allegation 2, subversion, discrediting, and impeding of the oversight role of the County Assembly. On 3rd September 2024, the governor engaged in gross misconduct and grossly violated the provisions of Articles 10, 73, 75, 174, and 185(3) of the Constitution, and abused his office by writing to the Speaker, purporting to direct the Speaker on, inter alia, the timelines the Speaker should give the chief officers who are summoned by the Assembly for questioning in exercise of the Assembly's oversight mandate. The Honorable Dr. Erick Kipkoech Mutai, how do you plead to ground 2, guilty or not guilty?
Not guilty.
Ground 3, gross misconduct. Particulars of this ground are as follows: allegation, bullying, incitement, vilification, and indecent sexual conduct. On various occasions, the governor has repeatedly engaged in 1, gross misconduct, and 2, gross violation of the provisions of Article 10, 73, and 75 of the Constitution, and Sections 29 and 34 of the Leadership and Integrity Act by A, publicly vilifying the residents of Kericho County with divergent views. A case in point is a Mr. Marwa from Londiani, who, while attending an event in Londiani on 4th March 2024, the governor publicly disparaged, demeaned, and undermined, and even threatened to use the services of the police officer assigned to him to manhandle him. Similarly, on 24th of August 2023, the governor, while commissioning a renal unit and a bulk liquid oxygen plant at Kipkoech Sub-County Hospital, the governor openly vilified, slighted, and berated the Honorable Amos Birir, MCA Kipkoech Ward, who had not attended the event, describing him as mentally blind and stupid. B, further, on 15th of August 2023, while addressing the press to counter the findings of the ad hoc committee of the County Assembly on Londiani accident, the governor spitefully referred to the members of the said ad hoc committee as the funeral committee. C, the governor has been operating with impunity as though he is above the law. On the second day of his being sworn into the office, the governor led a mob to invade a private land owned by one Mr. Josiah Kiplangat Kogo within Kericho town and tore down the fence. The governor has since designated the subject land as an illegal dump site operated by the county government without the consent of the registered proprietor. National Environment Management Authority, NEMA approval, gazettement by the county designating the parcel as a dump site, and in total disregard of a court order issued by the Environment and Land Court in the case of Kericho in ELC petition number E001 of 2022, Josiah Kiplangat Kogo versus County Government of Kericho. The governor has also obstructed the enforcement of the orders by the police administration. The actions are illegal, contemptuous to the authority and dignity of the court and the rule of law, unethical and demeaning the office of the governor holds. Further, as a result of the illegal actions of the governor, the county was condemned to pay the costs. D, there are numerous complaints of governors' indecent and unnatural sexual behavior by female partners who accuse the governor of, for instance, forcing them to unconsented anal sex, dangerous and unprotected sex, etc. The governor has persistently intimidated, molested, harassed county officers who do not sing to his tune, leaving officers jittery and creating an atmosphere of fear, uncertainty, and despondency in the county, and thus creating a toxic work environment. This violates the provisions of sections 11 and 13 of the Leadership and Integrity Act 2012. F, the governor has persistently used divisive and unbecoming language which undermines the office he holds, contrary to Section 8 of the Leadership and Integrity Act 2012. G, the governor has violated Article 75(1) of the Constitution by drawing hefty allowances and a salary while failing to diligently report to work, to the huge detriment of the discharge of his mandate as a governor and the performance of his functions. H, the acts of the governor enumerated above have collectively brought dishonor and disrepute into the office of the governor in violation of Chapter 6 of the Constitution and the Leadership and Integrity Act 2012. The Honorable Dr. Erick Kipkoech Mutai, how do you plead to ground 3? Guilty or not guilty?
I plead not guilty. Thank you, Mr. Speaker.
Thank you, Mr. Speaker, sir. For record purposes, my name is Elias Mutuma, appearing for the County Assembly of Kericho. I have two applications to make on preliminary basis. One, Mr. Speaker, sir, and honorable senators, is that you will notice from the presentations and the charges read that one of our witnesses is a young lady who will be appearing before Senate to testify on instances of sexual exploitation, molestation, to the extent of being forced into anal sex by the governor. To protect the integrity of the witness, Mr. Speaker, sir, we have made an application to have this witness protected so that she is not exposed to the world. We have written a letter to the Speaker where we have disclosed her true identity, even attached a copy of her ID. We have no problem with the witness being confronted by the governor. So we are requesting the Honorable House to allow that witness to testify in an environment where the world is not watching or where the world is not able to identify who she is. To that extent, we can allow counsel and the governor to meet the witness prior to the testing so that to providing her testimony so that they are able to know who the witness is. That application, Mr. Speaker, sir, is made pursuant to Rule 28 of that schedule. The second application, Mr. Speaker, sir, is that on Saturday at around 6:45, we were served with a response from the governor, and we noted that they have raised two preliminary issues. One on whether this motion met the threshold, that is being supported by 2/3 of the composition of the County Assembly of Kericho, and secondly, of a purported order that barred the proceedings from taking place. We have taken the liberty to prepare an affidavit on just those two issues. We have filed that application. We have served the same to my learned friend, Mr. Katwa, and we have also taken time to prepare enough copies for all the senators. We humbly seek that that affidavit, dated 13th of October 2024, be deemed as properly on record. That is all, Mr. Speaker, sir. I thank you.
Thank you, Mr. Speaker, sir, and honorable senators. We would first of all want to take exception at the statement made by my colleague for the County Assembly, saying as if it's a statement of fact that there was any sexual excesses. That is an issue for the courts and probably for this Senate. And so we take exceptions at the attempt to make it as if it's a statement of fact. For avoidance of doubt, we wish to say that there is no police report, there is no determination of that issue. Mr. Speaker, sir, I have 3 preliminary issues to request your audience on, Mr. Speaker, sir, and the Senate. The first one, Mr. Speaker, sir, is that we did in fact file our documents and a flash disk on Saturday, the 12th. However, it turned out that they were not properly paginated, and we have done a properly paginated set of documents and properly arranged flash disk. We very kindly request and plead with you, Mr. Speaker, sir, and the Senate to allow us to replace the improperly paginated document with a properly paginated one. The contents and the substance remains the same, and the same was served on my colleagues. May I say also that I have had occasion to have a word with my colleagues for the County Assembly, and the general understanding is that subject to your ruling, Mr. Speaker, sir, and the members of the Senate, we are in agreement that we are not contesting the affidavit that they have just introduced, the one dated 13th of October 2024 that my learned friend has referred to, and in exchange they are not contesting the replacement of the wrongly paginated bundle that we filed on Saturday, and we brought the corrected one on Sunday the 14th. Mr. Speaker, sir, other than that, I had indicated that we proposed to raise a preliminary objection to these proceedings, and we flagged out 3 issues we wanted to argue. Mr. Speaker, sir, I very kindly request for your audience on that application. The application to raise the preliminary objection is based on your Rule 14 and Rule 30, Mr. Speaker, sir. On issues of materiality and competence of the motion before you. I pray that you allow us audience on that preliminary objection. As my colleague has already indicated, they are aware of our preliminary objection and they are also ready to argue it. Mr. Speaker, sir, as an aspect of that application, we are aware that Rule 14 says that if you are to allow us to raise the preliminary objection, the time within which we can argue that a preliminary objection is 30 minutes. Mr. Speaker, sir, our preliminary objection, at least in our estimation, is very substantial. There is a rider in that Rule 14 that you can adjust the time within which it can be allowed. Mr. Speaker, sir, with that in mind, we would very much plead that you allow us 1 hour to raise the preliminary objection as opposed to the 30 minutes. And if you must, Mr. Speaker, sir, we would pray that you don't, but if you must, we are prepared to forfeit part of the time subsequently allotted to us for purposes of cross-examination of the witnesses for the County Assembly and for presenting our evidence the 3 hours thereafter. Mr. Speaker, sir, I rest my case there. Yes, Mr. Speaker, sir.
Just exhaust the 30 minutes first. And if at the end of the 30 minutes you still need time, you will make that application. Don't make it at this juncture. You will now proceed to raise your preliminary objection.
Right away, Mr. Speaker, sir. Yes, thank you very much, Mr. Speaker, sir. Mr. Speaker, sir, I trust you will allow me audience on the issue of the protection of the witness when it comes to that. Mr. Speaker, sir, the preliminary objection we wish to raise are 3. The first one, Mr. Speaker, sir, is that we wish to draw the attention of this honorable plenary and the attention of you, Mr. Speaker, sir, that there is an order that was made on 3rd of October 2024, and which we served to this honorable Senate, both the Senate as an institution and the Speaker, and that order in itself had the effect of asking that the Senate should not discuss this impeachment until the court has expressed itself.
Mr. Speaker, sir, in the face of that order which was duly served, we would very much pray that you consider standing down this impeachment until the court has entertained and determined that issue. Mr. Speaker, sir, the substance of that, we have availed the pagination of the case that is filed in Kericho, and Mr. Speaker, sir, we served you with both the petition and the application and the order. And for that reason, then, Mr. Speaker, sir, as a first preliminary issue, we pray for two things: that you do consider standing down this impeachment in the face of that order, and secondly, Mr. Speaker, sir, that Mr. Speaker, sir, the second preliminary objection that I wish to raise is that it is our argument that this impeachment is not.
Counsel.
Yes, Mr. Speaker, sir.
Or whatever you're saying is contained in your bundle.
Yes, Mr. Speaker,
You
sir.
can help the senators by referring to the bundle and the pages
Yes, Mr. Speaker.
so that you can flow with them.
Mr. Speaker, sir, the bundle and the order that I'm referring to is at page 387 of our bundle. It relates to Kericho Constitutional Petition number E011 of 2024. Dr. Erick Mutai versus County Assembly of Kericho. The Speaker, County Assembly, Honorable Rogoñ, the mover of the motion, the Senate, and the Speaker. And the order is at page 387 to 388. Mr. Speaker, sir, yes, volume 2. My apologies.
Counsel, talk closer to the microphone so that the senators can hear you.
Honorable Senators, I am referring to volume 2, page 387 to page 514, which contains the filings in Kericho High Court, Kericho petition number E011 of 2024, Dr. Erick Mutai versus the County Assembly of Kericho, the Speaker, Kericho County, Honorable Rogoñ, the Senate as fourth respondent, and the Speaker as the fifth respondent. And the order is at page 387 to 388, and it states at paragraph 5 that pending in the parties hearing of the motion dated 2nd of October, an order is issued to restrain the Senate and the Speaker from receiving or acting or presenting to the plenary of the Senate or allowing for debate the Senate, allowing for debate at the Senate.
No, honorable senators, can the council be heard in silence, please? Senator Allen, take your seat. If you want to consult, we have the lounge. It's empty as we speak. You may want to make use of it.
Thank you, Mr. Speaker, sir. I will read again the order. The order, which is material to this session, says that pending in the parties hearing of the motion dated 2nd of October, an order is hereby issued to restrain the Senate and the Speaker from receiving or acting or presenting to the plenary of the Senate or allowing for debate at the Senate as a plenary or at any other Senate committee or discussing or making any decision or resolution in regard to the impeachment of the petitioner in regard to the impeachment of the petitioner, the governor, Kericho County, on 2nd of October 2024. That is the relevant bit of that, and Mr. Speaker, sir.
Yes, Counsel for Governor.
Yes, may I explain?
Yes.
Mr. Speaker, sir, honorable senators, at the start of my presentation, I indicated that there is a first bundle that improperly paginated. There is a second bundle which definitely has that corrected pagination. I apologize for that.
Just hold on, Counsel, until we confirm the position.
That second bundle is like this. Mr. Speaker, sir, can I use the first volume? It has the same order. Probably it's easier to track it in volume 1, page 23. Volume 1 is the smaller one. Yes, volume 1, page 23, please.
So, Counsel for Governor, so that the senators can follow your arguments, indicate the bundle and the page. Then you proceed.
Thank you, Mr. Speaker, sir. If we all have volume 1, the same order exists in volume 1 at page 23. And then the rest of the pleadings in respect to that motion is in volume 2, as I indicated, page, the corrected bundle, page 387 to page 514. Mr. Speaker, sir, I would like to move on to the second preliminary objection. The second preliminary objection.
A minute,
yes, I'm
Counsel for.
I'm sorry, Mr. Speaker, sir.
Yes, Senator Roba.
Thank you, Mr. Speaker. On both volumes, the pages being referred to are not there. In volume 1 and in volume 2, the pages being referred to is not there. And it seems that maybe some of us may have the right document, others don't have, and it's very difficult to follow. So it's important that we are all on the same page in terms of having the right documents before we proceed. Thank you.
Senator Sifuna.
Honorable Speaker, I must say that I'm extremely disappointed from the onset in terms of the sort of filing that has been done by the governor's team. And perhaps at the inception of this hearing, all the parties need to introduce us to the documents they have filed. You need to be able to say, and I say this with the greatest respect because the Honorable Katwa Kigen is a litigation lawyer of no mean repute. But I must say that this is below standard because, Honorable Speaker, first introduce us to the documents you have filed. Say, my documents are colored, I think this is peach. I'm being told by the ladies that this is peach, Honorable Speaker, because the men should abstain from discussion.
Proceed, Senator.
Yes, Honorable Speaker, the volume that Council is referring to as volume 1 is in fact not paginated. Perhaps what he needs to do, because he had indicated that he had filed a separate volume that was properly paginated, let us allow him to withdraw the documents that are not properly